Okay, I gave a long introduction. This is part 2. Moving right along, I explained that the man here died of cancer in 2020. He made Yehuda Ferris of Chabad his trustee. And then the man who died left something for his 3 elderly Jewish siblings, but 5 years later they got nothing that they were supposed to get in the trust. And that's just an actual fact. Case number RP22120163. In short, the Jewish man who died of cancer after fighting it for 6 years never saw his own 2 Filipino daughters, licensed occupational therapists, Maxine and Flora Ziprin. They never once even called their own father in the whole 6 years he was dying of cancer. And they just confessed in this transcript, which I'll read to you. And so he left the trust. He said, I own half this house in Berkeley, 1810 Grant Street, which is 2 blocks from the trustee's latest synagogue. Yehuda Ferris, trustee of the trust, he was supposed to put a lien on the property with interest until paid in full, $30,000 times 3 to the man's elderly poor Jewish siblings. But 5 years later, he never put a lien on the property. He never paid him that $30,000. But it says, pay him the money or put a lien on the property, and only after all payments can you think about doing something with the house. But what did Yehuda Ferris do? And with his attorney, William Rogers, sold the property to the daughters for $80,000. But the trust said the daughters can't get the house. They can only get 25% each. It says, I own half the house. I'm giving a quarter to daughter 1 and a quarter to daughter 2 only. It's dependent on a certain settlement agreement, case number so-and-so. That settlement agreement says that they cannot get his entire half of the house, period. And then it says, I own half the house, give a quarter to daughter 1 and a quarter to daughter 2, and from the other 50%, pay my siblings, $30,000 each plus 10% interest a year, and if they don't get it, make a lien on the property at 10% interest a year until paid in full. And then it says, and then the trustee became a beneficiary. That's conflict of interest. And the lawyer, Will Rogers, attorney, license number 154219, he gets money out of the trust. That's also totally inappropriate, if not illegal. And then it says, after all payments have been made, then you can, the residual of the trust, you can divide up. But all payments were never made. It's 5 years later. 5 years later, and the siblings got $4,000. And they sold the property to the daughters for $80,000. Did you hear me? I mean, I'm not joking. This is serious. Okay? So the brother who took care of his brother went to court and sued. Okay? And he had like 6 lawsuits. And the judge said, okay, let's go to trial. That's what you're looking at right here. But then he didn't have a lawyer, so he said, okay, I'm dismissing without prejudice 4 out of 5 of my cases because I don't have a lawyer. I'm going to go get one and come back and refile. Dismissed without prejudice, except for this one that he couldn't. So that's what this transcript is about. And so that's what I'm going to start to read. And now it's 3 minutes, not 10 minutes introduction. So just bear with me on this. Okay, so as I started in the other one, this is part 2, right? It's case number RP22120163. Okay, the court is the judge, right? This is a transcript. Says, good morning. Calling the matter of Lee J. Ziprin, 2019 trust, dated August 26, 2019. He was already in a coma for months, and he wrote a trust. Who can write a trust when they're in a coma? Leave it to the trustee. And I think both parties have petitions, but for these purposes, could the petitioner state their appearance, please? Noah Margulies. All right. Mr. Margulies is here this morning on behalf of the respondents. Oh, and so this guy Horn, he represents the daughters who got the house illegally in violation of the trust for $82,000. So he's showing up. Yeah, because that's the deal of the century. Imagine that. You don't see your dad after 6 years of cancer. You totally ignore him. You abuse him by ignoring him. That's elder abuse. And then he dies and says they only get a quarter. And then the trustee sells it to him, sells him the whole $1 million worth of real estate, half the $2 million house, for $80,000. And now here comes their lawyer trying to defend the indefensible. Okay, Briar Horn. Okay, and the daughter's anti-Semites because, like most people whose father's Jewish but mother isn't, in the religion they're not Jewish, so then they're resentful. Well, Briar Horn is dad's Jewish and his mom ain't, so birds of a feather flock together. I might get sued for defamation and slander. Good morning, Your Honor. William Rogers on behalf of the trustee. Oh, yeah. Rabbi Yehuda Ferris, but he's never got ordination. Man. Mr. Horn, Briar Horn on behalf of Maxine Ziprin and Flora Ziprin. He's rich, $100,000 a year earning occupational therapist who never saw their dad in 6 years, but they got his house even though his trust said they couldn't. And then the lawyer's got a lawyer, Paul Nathan, on behalf of William Rogers. Why does a lawyer need a lawyer? The court, all right, and Mr. Horn, your clients are parties. It's fine for them to appear remotely. Are you going to be calling them as witnesses? Then remember, I need a declaration. Yeah, those declarations were submitted on Friday after the pretrial conference. I have copies here. Are they? They are. This is white-collar crime in action, ladies and gentlemen. Disregard that comment. Ladies and gentlemen of the jury, I see nothing on the register of actions. They were served on the other parties, and they were submitted to the court on Friday. Were they filed? Yes, submitted for filing electronically, and I have copies here. I'd like you to see them. Yeah, I will need to see those. I have reviewed the declarations of Flora and Maxine Ziprin, and the court will accept these declarations and allow them to appear remotely. Thank you, said the lawyer who got the $1 million worth of real estate for $80,000 reward for abandoning their father after 6 years of cancer and never saw his own daughters before he died. The court, all right, and so for the first issue we need to address is the 160.61 issue, and so the court attempted to review the case that you referred to, Mr. Margulies, Estate of Young, at C1 Cal App 4th 513. That does not exist. The court did find one case that was on point in regard to the form of the 16061.7, which is the Harristook versus Wickens 84 Cal App 4th 208, that appears to be the guiding principle for the court in interpreting this particular statute. And so, Mr. Rogers, Mr. Margulies, I wasn't finished with my presentation on Friday. I'm sorry, said the judge. I wasn't finished with my presentation. I had a lot more material, and you said see you on Monday. The judge says, okay, did you file something with the court? No, I just have my notes. Okay, to the extent that you are going to be referring to any case law, it's really important that you file with the court ahead of time so that the court can look at it and consider it. It's not only case law, it's statements. The court, if it's argument, that's fine. All right, but Mr. Rogers, this is your issue and Mr. Horn's issue, so I'll allow you folks to proceed on that. Mr. Rogers, if I may address this, yeah, he's the guy that wrote his trust when the guy was already in a coma. Yeah, you write a trust when you're in a coma? Oh, yeah, he can still write a he's in a deep coma for 6 months. Okay. If I may address this case in a broader sense first, the motion for judgment on the pleadings is Mr. Horn's motion, and I would probably, if you can speak louder, because I can't hear you. Yeah, he's too high. I might get sued for defamation. The acoustics in here are probably not the best for a voice as low as mine, the judge. And Madam Court Attendant, does Mr. Margulies have the assisted listening? Court, yes. And I have hearing aids. I was just asking you to speak more clearly. It was kind of muffled to me. Okay, so here we go. This is just sit back and relax, folks. That's the deep tone of my voice, and I don't know if I can change that. Is this any better? Maybe a little slower. Thanks. The judge. All right. That's the court's job. Just let me know if you're unable to hear. It's very difficult to understand you, by the way, so don't take offense. But all you need to do is talk slowly and carefully. So again, this is Mr. Horn's motion. He's the guy that represents the daughters who's got the $1 million worth of property for $82,000 in total complete violation of the trust. Nobody cares about the trust. He already died, so what? But I have a sense, and I think the attorney might have a sense of where this case is going. If we have this motion for judgment on the pleadings, this whole matter could take a couple of minutes, and I think this case, which has been going on now for 4.5 years, it's very difficult to understand from the outside what that's been like. Oh yeah, you sold the house for $82,000, and the 3 beneficiaries lost their brother after 6 years of cancer, and they never got a penny. And you're so upset because it's been 4.5 years. It's very difficult to understand from the outside what it's been like. Yeah, we're supposed to give them $30,000 plus 10% interest a year. Oh, and he wrote a trust giving them ownership, but you never told us about it. And you're complaining about having to go to court because you didn't follow the terms of the trust? How do you think they feel? They got $4,000 when they're supposed to get $50,000. And I think we could end this case in a 90-second hearing. That's what Roger says. It's going to be premature death. It's going to be a premature death to this case. I have a statement that I'd like to make. It started off being an opening statement for trial, but then I switched it because maybe being a statement. If we're starting a motion, maybe I could say it at the beginning of the motion. But I think there are things that need to be said for all the parties involved who have endured 4.5 years of this. And I'm afraid I want the court's leeway assistant to allow me to make that without starting the Holocaust for 6 years. This is a financial holocaust. I'll get sued for slander. The whole trial. So maybe we could start the motion, have the motion, and maybe statements without ruling on that motion yet. I think the court has probably read my pleadings. I've tried to be really concise. I'm going to provide a concise statement of 4.5 years down to 10 minutes. And I'd like to find a way to say that, Your Honor. All right. So the court has no issue whatsoever. Oh, of course not. So if you would like to do an opening statement and then allow the court to consider the motion on the pleadings, there's no problem with that. Right. You could say everything. I can't say nothing. Right. So, all right. So let's talk about the motion for the judgment on the pleadings. So when the court ruled on that motion, it appears that the court, we're going a long thing here, that the court ruled on that motion. It appears that the court said there was merit to the motion, but we didn't have sufficient information about when Mr. Margulies received the notice, the 16061.7 notice, and wanted to hear some evidence. So I understand that Mr. Rogers' offline office served the notice, which is why I turned to him this morning, because the court does want to hear some evidence in regard to that document and have that document in front of us. Mr. Horn, he represents the daughters who never saw their dad in 6 years, but they got the house even though their own father said they couldn't, and got it for $80,000, and the 3 siblings who were poor, starving, and homeless got $4,000. But the daughters got the house even though they're making $100,000 a year as licensed occupational therapists, and one lives in L.A. and one lives in Washington. So they could care less about the house. But the siblings could have used it because that's what their brother said. Their brother wrote a trust before he went into a coma a year earlier, and he said, give them 25% of my half of the house. But then they came up with this other trust when he was in a coma. He wrote a trust when he was in a coma. Have you ever heard of that? That's a good one, right? Okay. Oh, well, having said that, so the attorney for the daughters. Okay, well, having said that, Maxine and Flora Zipplin would like to call William Rogers to the stand. All right. Am I going up there, Mr. Rogers? The judge. Since you have a good seat, why don't you just stay in the seat that you're in? But are you hearing him okay? And Margulies says yes. That's the brother of the guy who he got $4,000. They got $1 million worth of real estate for $80,000. The sisters got $4,000, and the lawyer got $57,000 now in attorney's fees.